So Raminta Gostautaite from Prosecutor General Office of the Republic of Lithuania, and she will talk about young suspects in Lithuanian criminal proceedings.
Okay, now I'll try to share my screen. Can you see my slides?
Yes, now.
Okay. So my theme of today's presentation is quite wide, so I'll try to concentrate only on some things which are, in my opinion, meaningful and useful in the context of this conference. So first of all, I would like to mention that under Lithuanian Criminal Code, criminal liability may arise for individuals only from the age of 16. But if a more severe crime has been committed, then criminal liability may arise from the age of 14. So today in my presentation, I will talk about juvenile suspects who are 14, 17 years old. At first, I would like to provide you with some statistics. As you can see, the number of juvenile suspects in 2019 and 2020 in Lithuania was almost the same. For comparison, I took the number of all suspects, and you can see that the percentage of juvenile suspects is approximately 5% of all suspects. In this chart, you can see how many crimes and misdemeanors have been made by juveniles in 2019 and 2020 in Lithuania. And in this chart, I put more detailed statistics about crimes committed by juveniles. As you can see, the most popular are thefts, then non-severe negligible health impairment, then violation of public order, possession of drugs. Such severe crimes as murder, severe health impairment, and sexual abuse, for example, are not very common, and the numbers are quite small. So what guarantees that juvenile suspects, taking into account their maturity and age, could properly use their rights in criminal proceedings, and what measures do we have in our legal regulation that help juvenile suspects to not to get lost in this difficult investigation process and be full participants of in the criminal proceedings. So here you can see a huge list of juvenile suspects' rights. They are in our criminal procedure code, and these rights are such as right to receive information on the status of criminal proceedings, right of access to a lawyer, right to interpretation and translation, right to testify or to refuse to testify, and others. In 2019, provisions of the Directive on Procedural Safeguards for Children who are suspects or accused persons in criminal proceedings have been transposed to national law. So now in our criminal procedure code, we have few more rights, which are given especially for juvenile suspects. So it's the right to be accompanied by the legal representative, and the right to protection of privacy, then right to defend herself through a defense counsel, also right to have parents, step-parents, guardians immediately notified about the rights of a juvenile suspect, right to health checkup, right to request an audio-video recording to be done during the interview, and a right to participate during the individual assessment. In 2019, we created a protocol of notification of juvenile suspects' rights, and its annex, and these all rights are listed in one written document, which is given in written form for a juvenile when he gets the status of the suspect. These documents have been approved by the order of Prosecutor Generals, and has been have been translated to 5 foreign languages. I will not talk about all these rights, but I will just say some aspects which may be useful in the context of this conference. So first of all, a juvenile suspect has right to have a defense lawyer. And under Lithuanian Criminal Procedure Code, in cases where the suspect is juvenile, participation of a defense lawyer is obligatory. This defense lawyer can be selected by the juvenile suspect or by his or her legal representative. But if a juvenile suspect or his or her legal representative do not have enough money to pay for a private defense lawyer, then he or she can be provided with legal aid guaranteed by state. Another very important thing is that that guarantees that a juvenile suspect gets legal assistance in criminal proceedings is if a juvenile suspect refuses to be defended by a defense lawyer, this refusal of him or her is not obligatory for a pretrial investigation officer, prosecutor, or judge. It means that in all cases where the suspect is juvenile has its own defense lawyer. Also, I think it's important that if juvenile suspect is detained or arrested, then he or she has a right to see his or her defense counsel in private. Another very important right is the right to have a legal representative. Under our Criminal Procedure Code, as a legal representative can be assigned parents, step-parents, guardians, relatives, and if there are no such people, then the child rights specialist can be also assigned as a legal representative. It is very important to select a proper legal representative who can act in favor of interests of a juvenile suspect. Because in practice, sometimes pretrial investigation officers are not very observant and select legal representatives who cannot properly help juvenile suspect to use his or her rights in criminal proceedings. I can provide you with one example from the practice when a child who lived in child care institution used sexual abuse against another child who also lived in the same child care institution. And the pretrial investigation officer, as a legal representative, assigned specialists working in the same child care institution. So it means that the same subject, the same child care institution, was the legal representative of or the suspect juvenile and also the victim juvenile, whose interests are absolutely opposite. So it's just one example, and it is very good that such examples are not very common. So in such cases, if a participation of a legal representative were contrary to the best interests of a juvenile suspect or would prejudice criminal proceedings, another legal representative can be assigned. This legal representative can be selected by the juvenile suspect or by pretrial investigation officer, prosecutor, or judge. Why it is important for a juvenile suspect to have a legal representative is that legal representative can accompany juvenile suspect in criminal proceedings. For example, go with him together to court hearings, pretrial investigation actions, and what is the most important, help him or her use his and her procedural rights. Also, we have special rules, special order of the interrogation of juvenile suspects. As I mentioned before, when the juvenile gets his or her status or the suspect, he or she is provided with the list of his rights and have with his signature confirm that he or she understands all these rights which are written. Very important is that a juvenile suspect has not a duty but a right to testify. That means that a juvenile suspect can choose to testify or refuse to testify. Even he can decide to testify but not to answer certain specific questions. Under the Lithuanian Criminal Procedure Code, also a psychologist can be invited to participate in the interrogation of a juvenile suspect and help to interrogate a juvenile suspect depending on her social and psychological maturity. Also, Child Rights Protection Agency specialist can be invited to the interrogation of the juvenile suspect, and this specialist participating in the interrogation observes if the rights of the juvenile suspect are not being violated during the interrogation. Another important thing that if a juvenile suspect or his or her legal representative or defense counsel requires, then an audio and video recording can be made during the interrogation. Also, this audio-video recording can be made if pre-trial investigation officer, prosecutor, or judge sees that it is necessary. And also, there is an imperative that if a juvenile suspect is detained or arrested, then an audio and video recording must be made in all cases. In Lithuania, we have specialized prosecutors who work exceptionally with the cases of juvenile justice. And they have special knowledge, special skills. They often participate in various trainings to keep their competence high. And one new thing that last year in one police stations of Vilnius district, there was an experiment when specialization of juvenile justice has been set for pre-trial investigation officers. This experiment was really successful, so today we have specialized pre-trial investigation officers in all police stations in Vilnius district. However, we do not have judges specialized in juvenile justice cases, but this problem has been discussed for a very long time, so we hope maybe in the near future we also have judges specialized in juvenile justice. The last thing which I want to talk about is penalties for juvenile suspects. Under Lithuanian Criminal Code, the purpose of the juvenile criminal liability is not only to punish, but also to ensure that criminal liability corresponds to the age and maturity of the person and help children to change their way of life, combining punishing for committed crime and development of personality, and also eliminating causes of the criminal behavior. So if a juvenile commits a misdemeanor or a negligent crime or a minor or less serious premeditated crime for the first time, he or she can be released from the criminal liability under certain circumstances. For example, if she pleads guilty and regrets having committed a crime, or there are other grounds for believing that in the future the minor will abide by the law and will not commit new criminal acts. If the judge releases a juvenile from the criminal liability, then some reformative sanctions always are imposed. For example, compensation for or elimination of property damage and paid reformative work and others. Talking about penalties for juveniles, I can say that they are the same as for adults. It's the difference is just that for juvenile penalties are much milder. For example, maximum term of a custodial sentence for an adult can be 25 years, or for a juvenile only 10. Moreover, life sentence for a juvenile cannot be imposed, and even a fixed term custodial sentence for a juvenile can be imposed only in very exceptional cases, when a judge sees that any other penalty won't be effective, or if a juvenile commits serious or grave crime. So I see my time is over, and I hope that my presentation was useful for you, and thank you very much for your attention.